The Supreme Court just dropped a 9-0 unanimous bombshell that changes everything for gun owners during police encounters. This ruling fundamentally rewrites how your Second Amendment and Fourth Amendment rights work together, and it could be the difference between walking away from a traffic stop or ending up in cuffs. The justices completely rejected the approach that let police treat your constitutional rights like suggestions. If you legally carry a firearm, this case affects you directly. Subscribe now to get the latest cases and updates that affect your freedom every day. You won't believe how this case started. As I mentioned, we're breaking down this massive 9-0 unanimous ruling that just came out of the Supreme Court. This case involves both your Second Amendment right to carry and your Fourth Amendment protections against unreasonable searches and seizures, specifically what happens when law enforcement encounters armed citizens and crosses the line into excessive force that violates both constitutional protections simultaneously. The case that started all this is Martinez versus State Police. This lawsuit should be on every gun owner's radar because it directly addresses how courts must analyze situations going forward when police encounter lawful carriers and when their actions violate multiple constitutional rights at once. Although this case deals with more than just typical search and seizure issues, it fundamentally changes the seizure doctrine and how use of force gets evaluated under both amendments. As gun owners, we've seen too many situations where police interact with legal carriers, and through poor training or constitutional ignorance, someone with a permit ends up arrested, injured, or dead. This Supreme Court analysis directly impacts those situations and strengthens your rights in these dangerous encounters. What actually happened will shock you. The facts of this case will absolutely infuriate you. Carlos Martinez, a lawful concealed carry permit holder with zero criminal history, gets pulled over for a minor traffic violation, expired registration tags. Following his state's requirements perfectly, Martinez immediately informs the officer that he has a valid carry permit and is currently armed. He keeps his hands visible, stays calm, does everything by the book. Here's where it goes sideways. Instead of simply running Martinez's permit through the system, the officer immediately demands surrender of the legally carried weapon. Martinez complies, but respectfully asks what legal authority requires him to disarm during a routine traffic stop for expired tags. That question apparently triggered the officer, who calls for backup and starts treating Martinez like an active threat. When backup arrives, 3 officers now surround Martinez's vehicle. They order him out, force him to the ground, and during the weapon seizure process, one officer uses what the court later called clearly excessive force, twisting Martinez's arm behind his back so violently it required medical treatment. They confiscated his legal firearm without any probable cause of criminal activity. The entire timeline is crucial here. About 4 minutes elapsed from initial stop to injury. About 45 seconds passed between Martinez's respectful question about legal authority and the officer's call for backup. Martinez never resisted, never threatened anyone, never did anything except exercise his constitutional rights. Yet he ended up injured and disarmed for following the law perfectly. Legal precedent and lower court rulings. Martinez's response was exactly what you'd expect from any American who knows their rights. He sued the state police, alleging that officers violated both his Second Amendment right to lawful carry and his Fourth Amendment protection against unreasonable seizure. This should have been a slam-dunk case, right? Wrong. The district court granted summary judgment in favor of the officers, applying what they called the Officer Safety Exception Rule. Basically, they said police can immediately disarm any citizen during any encounter, regardless of legal carry status, because officer safety trumps constitutional rights. This garbage ruling then made its way to the Circuit Court of Appeals, and they doubled down on the stupidity. The appeals court affirmed, explaining that the officer safety exception allows automatic disarmament of any armed citizen during police encounters, period. Under their twisted logic, your concealed carry permit becomes worthless the moment police show up. They completely ignored that Martinez was exercising 2 constitutional rights simultaneously and instead created a precedent that treats legal gun owners like criminals by default. Supreme Court decision and reasoning, thank God for the Supreme Court, because they saw right through this constitutional garbage. On review, the 9-0 unanimous ruling completely demolished the lower court's reasoning. The court held that any claim involving both Second Amendment carry rights and Fourth Amendment seizure protections requires what they called a dual constitutional analysis that actually protects both rights simultaneously instead of pretending one doesn't exist. Here's the game changer. They flat out rejected the officer safety exception nonsense. The court ruled that police cannot automatically disarm legal carriers just because they feel like it. They established something called the constitutional harmony doctrine, which means both your rights must be protected at the same time, not sacrificed for officer convenience. The court's reasoning was absolutely brutal toward the lower courts. They stated that the Second Amendment's protection of lawful carry cannot be nullified merely because a citizen encounters law enforcement. When a citizen is lawfully exercising Second Amendment rights, Fourth Amendment seizures must meet a heightened standard of reasonableness that acknowledges the constitutional nature of the conduct. They continued, while officer safety remains important, the lawful exercise of constitutional rights cannot be suspended based on generalized safety concerns or officer preference. The totality of circumstances must include the citizen's legal right to carry firearms. This completely rewrites how police must treat lawful gun owners. Why this changes everything for gun owners. This case is absolutely critical because it impacts every single gun owner's constitutional protections during police encounters. For concealed carry holders, this is genuinely game-changing right now, especially considering all the horror stories we've seen where lawful gun owners get disarmed, arrested, or even shot by police officers during routine stops when they properly disclose their legal firearms. This ruling means police departments can no longer hide behind blanket officer safety policies that treat your constitutional rights like privileges they can revoke at will. The Supreme Court just handed you stronger legal protection that prevents automatic disarmament policies and forces law enforcement to actually respect both your Second and Fourth Amendment rights simultaneously. Police training will have to change, department policies will have to change, and most importantly, officers who violate this new standard will face real consequences. This decision strengthens both constitutional protections working together, which is exactly what gun owners have needed for years. What gun owners should do right now. Okay, so now that you understand how this Supreme Court ruling changes everything, let's talk about what you need to do immediately to protect yourself and take advantage of these new constitutional protections. First, if you're a concealed carry holder, you need to update your knowledge of how to handle police encounters. The old advice of just comply with everything isn't necessarily the best approach anymore. You now have stronger legal ground to stand on. But that doesn't mean you should start arguing with officers on the side of the road. The key is knowing your rights while still being smart about how you exercise them. Document everything. If you're ever in a situation where police demand your weapon without clear legal justification, you need to comply for your safety, but make sure you're documenting the encounter. Use your phone to record if possible. Get badge numbers. Ask for the legal authority they're citing. This Supreme Court ruling gives your attorney much stronger ammunition in court, but only if you have evidence of what actually happened. Here's something crucial. If you've been in a situation where police violated your rights before this ruling, you might have new legal options. The constitutional harmony doctrine the court established could apply retroactively to pending cases. If you were disarmed illegally, arrested without cause, or injured during a lawful carry encounter, contact a constitutional attorney immediately. This ruling could completely change the outcome of your case. For those of you in states with constitutional carry, this ruling is equally important. Just because your state doesn't require permits doesn't mean police can treat you like a criminal for exercising your rights. The same dual constitutional analysis applies whether you have a permit or you're carrying under constitutional carry laws. Finally, share this information. The more gun owners who understand these new protections, the faster we'll see real change in how law enforcement treats lawful carriers. Police departments are going to have to retrain their officers, and that process will go smoother if officers know that citizens understand their rights under this new Supreme Court standard. Conclusion. This 9-0 unanimous ruling fundamentally changes how Second Amendment carry rights and Fourth Amendment protections work together, and it's never been more important for gun owners to understand these constitutional intersections because of what's been happening in police encounter situations across the country. Have you ever had a police encounter while legally carrying that made you question your rights? Drop your experience in the comments below.